why the DOJ's Sanctuary City lawsuit against Illinois was dismissed. In a landmark ruling that has sent shockwaves through the political landscape, a federal judge has thrown out the U.S. Department of Justice's DOJ lawsuit targeting Illinois, Cook County, and Chicago over their Sanctuary City policies. This decision not only marks a major legal victory for the state and local officials, but also reignites a fiery debate about the balance of power between federal and state governments. And here's where it gets controversial. The judge's reasoning hinges on a principle that many argue could reshape how federal agencies interact with state and local laws in the future. But let's break this down step by step. The DOJ had accused Illinois and its local jurisdictions of obstructing federal immigration enforcement by implementing policies that limit local law enforcement's cooperation with federal immigration authorities. Specifically, the lawsuit targeted rules that prevent local police from inquiring about a person's immigration status or sharing such information with federal agents unless required by law. However, U.S. District Court Judge Lindsay Jenkins dismissed the case, citing a critical legal barrier. The federal government lacks the legal standing to sue state and local officials over these policies. The judge's ruling emphasized a foundational constitutional principle. While Congress holds broad authority, it cannot compel states to act as enforcement arms for federal programs. As the court stated, the federal government may not wield states as federal tools. This dismissal, though not with prejudice, leaving the door open for the DOJ to refile the case, has sparked questions about the practicality of such an appeal. ABC7's chief legal expert, Gil Soffer, noted that the DOJ would need to present an entirely new set of facts to justify a renewed lawsuit, a high bar in legal terms. Judge Jenkins has given the DOJ until August 22nd to amend its complaint, but the clock is ticking and the stakes are high. The reactions from state and local leaders have been celebratory, with Illinois Attorney General Kwame Rowell hailing the decision as a validation of the Trust Act, a state law that prioritizes federal responsibility for immigration enforcement. Today's decision affirms that local law enforcement should focus on protecting their communities, not being pressured into federal immigration battles, Rowell stated. Governor J.B. Pritzker echoed this sentiment on social media, declaring it a win for the rule of law. Meanwhile, Chicago Mayor Brandon Johnson framed the ruling as a defense of the city's decades-old Welcoming City Ordinance, which he argued enhances public safety by fostering trust between immigrant communities and law enforcement. But here's the part most people miss. The ruling doesn't just affect immigration policy. It raises broader questions about federal overreach and the limits of intergovernmental authority. Critics of sanctuary policies argue that such laws create dangerous loopholes for criminals, while supporters insist they protect vulnerable communities and encourage crime reporting. This case and the judge's decision force us to confront a thorny issue. Should states be allowed to opt out of federal mandates when they conflict with local priorities? Or does that undermine the unified enforcement of national laws? As the DOJ weighs its next move, the legal battle could escalate, potentially reaching higher courts. For now, though, the dismissal stands as a reminder of the judiciary's role in safeguarding state sovereignty, a principle that has divided lawmakers and citizens for decades. We want to hear from you. Do you believe the federal government has the right to compel states to cooperate on immigration enforcement? Or should states have the freedom to set their own policies, even if it means defying federal pressure? Share your thoughts in the comments below. Federal judge dismisses Trump's lawsuit against Chicago over Sanctuary City policies. Picture this: a high-stakes battle over who calls the shots on immigration, where a federal judge just sided with states' rights by dismissing the Trump administration's attempt to challenge Chicago's sanctuary policies. It's a decision that underscores the tension between local autonomy and national authority, and it's bound to get people talking. In a detailed 64-page ruling, Judge Lindsay C. Jenkins, appointed by Joe Biden, agreed with Illinois' argument that the federal government doesn't have the legal footing to bring this case forward. At the heart of it, the judge pointed to the 10th Amendment of the Constitution, which acts like a built-in check on federal power. Think of it as the Constitution's way of saying that if Washington doesn't have explicit permission for something, it's up to the states to handle it. In this scenario, Illinois chose not to join in on civil immigration enforcement, and the judge said that's perfectly protected under that amendment, No strings attached from federal law. But here's where it gets controversial. The ruling suggests that these sanctuary policies aren't just about local control. They're seen as a shield against what some view as overreach by the feds. The judge even warned that letting the lawsuit proceed would be like a sneaky workaround that ignores the 10th Amendment's boundaries. Illinois Governor J.B. Pritzker was quick to celebrate the win, emphasizing that his state will only help federal efforts when they're done by the book, like with proper warrants for violent offenders. He made it clear that Illinois won't be part of what he calls the administration's oversteps. Meanwhile, the Justice Department hasn't chimed in yet, leaving us wondering about their next move. To give you some context, this lawsuit kicked off back in February, when the Trump administration targeted Illinois and Cook County, home to Chicago, for policies that limit how local law enforcement can assist with immigration crackdowns. Without a criminal warrant, these rules block cooperation on civil matters, which the feds argued was a major roadblock to keeping everyone safe. It's not an isolated incident, though. The administration has been on a roll, filing similar suits against places like New York City and state, accusing them of undermining immigration enforcement. For instance, they went after New York's green light law that lets undocumented immigrants get driver's licenses without sharing data with immigration officials. And they sued Los Angeles for treating federal agents differently. All of this stems from an executive order Trump signed earlier in the year, pushing for penalties like cutting funds to these so-called sanctuary areas. And this is the part most people miss. While sanctuary policies are often praised for building trust in communities, imagine an immigrant feeling safe to report a crime without fearing deportation. Critics argue they create loopholes that could let dangerous individuals slip through the cracks. It's a debate that's far from settled, with strong opinions on both sides. What do you think? Do these state-level decisions empower communities or weaken national security? Should the feds have more say, or is local control the way to go? Jump into the comments and let us know your take. I'm curious to hear how you'd navigate this tricky balance. Judge dismisses Trump admin's lawsuit against Illinois, Chicago, over sanctuary city policies. In a stunning rebuke to the Trump administration's hardline immigration stance, a federal judge has thrown out a lawsuit targeting Illinois and Chicago's sanctuary city policies, exposing deep divides over state rights and immigration enforcement. This decision not only protects local autonomy, but also challenges the federal government's authority to dictate how states handle immigration issues. But here's where it gets controversial. While the ruling is celebrated by advocates for immigrant rights and state sovereignty, critics argue it undermines federal efforts to ensure national security and enforce immigration laws uniformly across the country. On Friday, U.S. District Judge Lindsay C. Jenkins of the Northern District of Illinois Eastern Division dismissed the lawsuit in its entirety, stating that the Trump administration lacks the legal standing to challenge state and local laws that limit cooperation with federal immigration authorities. In her ruling, Jenkins clarified that the sanctuary policies in question do not regulate immigration and customs enforcement, ICE operations, or infringe on the rights of private individuals working with ICE. This decision effectively shields Illinois, Cook County, and Chicago from federal overreach, emphasizing the 10th Amendment's protection against direct federal regulation of states. And this is the part most people miss. The judge also ruled that forcing local law enforcement to assist federal agents in deportation efforts is unconstitutional. This ruling underscores the delicate balance between federal authority and state autonomy, a debate that has raged for decades. For instance, compelling states to enforce federal immigration laws could set a precedent for the federal government to commandeer state resources for other purposes, a move many see as a threat to states' rights. Since returning to office, President Donald Trump has aggressively targeted sanctuary cities, labeling them as threats to national security. In February, his administration sued Illinois and Chicago, claiming their policies, such as the Welcoming City Ordinance and the Illinois Trust Act, obstruct federal immigration enforcement. The lawsuit also named prominent figures like Illinois Governor J.B. Pritzker, Chicago Mayor Brandon Johnson, and Cook County Sheriff Thomas Dart, accusing them of intentionally hindering federal efforts to deport undocumented immigrants. Governor Pritzker, a potential 2028 presidential candidate, celebrated the ruling on social media, stating Illinois just beat the Trump administration in federal court. Their case challenging the Bipartisan Trust Act was dismissed. Unlike the president, we follow the law and listen to the courts. Cook County State's Attorney Eileen O'Neill Burke echoed this sentiment, arguing that the Trump administration's tactics are not only unlawful, but also counterproductive to effective crime fighting. She emphasized the importance of building trust with immigrant communities to ensure victims and witnesses feel safe coming forward. However, the White House swiftly countered, claiming that sanctuary cities like Chicago endanger Americans. Abigail Jackson, a White House spokesperson, stated that government at all levels has a duty to protect American citizens from harm. Sanctuary cities interfere with federal immigration enforcement at the expense of public safety. This clash of perspectives raises a critical question. Can states and cities prioritize local values and trust building without compromising national security? This ruling is part of a broader legal battle between the Trump administration and Democratic-leaning states and cities. Just a day earlier, the Justice Department sued New York City over its sanctuary policies, following an incident where an off-duty Customs and Border Protection officer was shot by undocumented immigrants. Similar lawsuits have been filed against Colorado, Los Angeles, and New York State, highlighting the administration's determination to dismantle sanctuary policies nationwide. But is this a fight for national security or an overreach of federal power? Critics argue that the Trump administration's approach alienates immigrant communities and undermines local law enforcement's ability to build trust. Proponents, however, see it as a necessary measure to uphold federal law and protect citizens. What do you think? Is the federal government justified in challenging sanctuary cities? Or should states have the final say in how they handle immigration? Let's continue this debate in the comments. Your perspective matters.